Good afternoon and welcome back to Law and Crime Trial Network. I'm your host, Brian Buckmire. Now, we are still doing the verdict watch with the Rosenbaum case. They've had the case for some hours now, so we're waiting to see what happens. Make sure to stay tuned because at any point in time we can get a verdict as to both Rosenbaums, either to whether or not they're guilty or innocent and what charges may apply. Now, in the Nachtman case, we are front row center watching the rebuttal witness for the prosecution. We're going to go right live to see what she has to say. So just to give some context that we have a sidebar here, this is the the prosecution's rebuttal witness. Now I'm joined here by our guest, Michael Koribanics, as well as Brian Wagner. Good afternoon to you guys both. Good afternoon. Nice. Now I want to go first to Mike because you had a comment as to rebuttal witnesses. Good, bad, somewhere in between?
I always, as you know, I'm pretty pro-defense, but I always really feel that if I put on a defense and I have the prosecutor put on rebuttal, I've hurt their case because now they're chasing me. Momentum has changed and they're chasing me. Obviously, there's something my experts brought up in my defense that they feel they didn't address in their major case in chief, and now they're chasing me. So I think this is a good point for the defense.
All right, Brian, same question. How do you feel about rebuttals for prosecutors?
I completely agree. I used to be a prosecutor. If I'm chasing the defense case, I've lost my message. If it's really an important witness, I put it on my case in chief. Everything else is the defense trying to deflect. And so a rebuttal witness is usually unnecessary.
So, and I agree. It seems peculiar. It seems strange. But then I understand that we're pro-defense here. But what about also the defense's own cross-examination? I mean, she's going into the fact that this witness had abuse herself, and I guess trying to suggest that maybe her previous abuse might color the interview with the defendant in some way. Mike, how does that play out?
Well, I think of it more as a subliminal thing that they're bringing out on cross-examination here. I mean, here you're arguing because of abuse, your client was incompetent, wasn't fit, couldn't understand the repercussions of their actions. Now you have an expert who you're trying to qualify as an expert who's unfortunately undergone the same sort of abuse. I think that really, on a very subconscious sort of background music type of way, tells the jury, maybe this witness isn't really as credible as we think because of her past, because this is what they're arguing to exculpate their client.
I mean, Brian, same question, but I'll add this little twist to it. I mean, you worked in the DA's office, you're a defense attorney now, I'm a defense attorney, Mike's a defense attorney. I think if you go to any lawyer generally, regardless of area of law they practice, they will say, I'm a defense attorney because something in my own personal past. If you ask a doctor that, you ask a therapist that, you ask an athlete that. I mean, we pick professions if we're lucky enough to get the profession we like based on some personal experience we had. So what is this then?
So all that's correct, but also from the defense in terms of crossing this expert, just muddle the people's case, confuse the jury. Confusion helps the defense, and that's what this cross-examination about the doctor's own past really does. It makes the jury question, why do we care about this witness? Why do we trust this witness? Even if you're not going to get any points in terms of really proven anything, you just want to confuse the jury at a certain point.
Yeah. Now, I promise that we might have 3 defense attorneys here, but we are not going to confuse our viewers. Make sure you come back right here at Law and Crime Trial Network after this break. So we're continuing on the stand with this rebuttal witness. As we're listening to some of the testimony, I won't lie, I think my guests and I are kind of drifting in and out. We're hearing things that are important, we're kind of losing ourselves. And I mean, I'm a host, I'm working, this is my job, I'm getting paid, and you guys are here. Mike, can you imagine a juror? I mean, you came here with your seersucker suit, ready to go, and you're kind of losing track of what's going on. How is this working out for a juror?
I think it's tough. I mean, other than the fact she has great glass frames, but this cross-examination really is, to me, counterintuitive. I always look at cross-examination for the good trial lawyer. It's almost like jazz music. You got to get a rhythm, you got to get a flow, and you've got to be able to move in between those notes. We're not seeing that here. We're seeing long, drawn-out dissertations where it's just going nowhere, and I really am having a tough time of what's the point of this. So I think jurors are really losing this as well.
And then Brian, you were talking about different styles of cross-examining where you can go through a laundry list of things to show, okay, you didn't do this, you didn't do that, you didn't do that, to show incompetence to some degree. Or you can be very punchy and just be like, question, question, question. I mean, is there any other style that we're missing that she's maybe employing?
Not really. I mean, look, Mike's right. A cross-examination is, he said off air, like a summation. It's your testimony. The witness is just there just because someone has to be up on the stand, but you're asking questions that you don't really care what the witness's answer are. What I find is really happening here is this attorney is trying to out-expert the expert. No matter how much this attorney knows, this expert has forgotten more than she will ever know. And so you're not going to be able to outsmart the expert. All you could do is lay the foundation for whatever you need on summation, and then sit down and stop talking, because like you said, the jury loses interest.
Yeah. And the thing too is, as defense attorneys and even prosecutors, you've got to know who your audience is. I'm getting a very weird vibe that it's the defense attorney and the witness, and it seems like the defense attorney only believes that it's just her and the witness on the stand, but you've got to present the information for the jury to understand. So maybe, because I haven't studied this, maybe she is very sharp on the law, very sharp on this person's area of expertise, but I'm losing track of it, and I can't imagine that the jury isn't. Mike.
Well, you know, you make a good point. I mean, being the youngest guy on this panel today, but I do understand about tweets. And that's the world we live in. People want to hear things in short sound bites, and that's what the jurors want to hear. There's no short sound bites here. There's just lingering questions with open-ended answers. I mean, the expert really gave a dissertation on the opening of that book, and that's not what you want as a cross-examiner. You want to control where you're leading your facts in your case.
Brian, maybe, all right, we're all defense attorneys. Let's be on her side. Maybe we can't see the trees from the forest. Maybe she's getting really detailed and there's a bigger picture, or the forest from the trees, if I said it incorrectly. And maybe when she comes back at summation, she's going to connect it all. Could that be it?
It could be, but if that's the goal, she's not doing it very effectively. A cross-examination is not a fact-finding mission where you're asking open-ended questions, what happened, and then what happened? No, you're making points. It's like what I said before, short declarative questions. You didn't review this, correct? You don't care what the answer is because the question's already in the jury's mind. You didn't do this, correct? She didn't exhibit this, correct? And then on summation, you really tie it all together. But that's not what this cross-examination is. It's too open-ended, too wandering, not really pointed enough.
Yeah. We're going to continue to follow this case and also have the verdict watch more after this break. So we are currently in verdict watch for the Rosenbaum case. If you're following, yesterday they had a full day, 8 hours of deliberation. Today they're at about 4.5 hours. That's about 12.5 hours, maybe more. Now, of course, there could be more time in the deliberation. We are obviously watching to see if there are any notes. Again, notes from the jury are to ask whether or not they can get readbacks or view other evidence. But right now, we're trying to see whether or not they come back with guilty verdicts for both Rosenbaums. Remember, Jennifer and Joseph Rosenbaum are being represented by one defendant attorney. It's unsure what's going to happen next. The jury has been sequestered, meaning that they are separated from everyone else. They can't go home. They're staying in hotels because they are not allowed to speak to other people about the case. They're not allowed to research or even look at the Law&Crime network as much as they might want to get more information about what's going on in the case. Now, they deliberated yesterday until 8 p.m. Before going to their hotels, and they're allowed to go late again tonight if they wish. So we might get another, either we're hoping for a late night verdict as we got in the Amato case, but they might be deliberating all the way until 8 p.m. tonight. Again, that's about 12.5 hours of deliberation. We are watching there tentatively to see if we get a verdict out of them. We now want to flip back to the Nachtman case. Again, this is the Florida case where the woman is being charged with killing not only her mother, but her stepfather. Brian, crazy case. I mean, let's look at it from an overall perspective. You've got a young girl in college who drives. Now, I don't know my Florida geography as best as other people, but I looked it up. This isn't like a 30-minute drive. This is like a 4-hour drive where the defense attorney is trying to say that she snapped. But drives 4 hours, gets to the place, kills the stepfather accidentally, purposely, whatever, cleans it up, waits for the mother, sets a trap. Is what she's being accused of, and then allegedly kills the mother as well. If you were the defense attorney, what would you try to aim for to try to prove your case here?
So one, it's not my case to prove. it's the DA's case to prove. And I've presented a good defense in terms of why her actions might be excused, or at least put in context. That's really what I'm trying to do. Put her actions into context. Her abusive past, the fact that she drove a long way, just shows how abusive her mother was to her. And then let the DA prove their case beyond a reasonable doubt. But again, what we're trying to do is confuse the jury, or confuse what the actual issue is. The issue is whether or not that 4 hours is enough to settle back in and have mental acuity. I'd argue that it's not. And that so long the doctor is testifying to the fact that you could be in a mental lapse for 4, 6, 8 hours.
Let's see what's going on in the court as this cross-examination of the rebuttal witness continues. While the witness is refreshing her recollection, let's refresh our recollection of this case. Mike, similar question. As the facts of this case rolls out and the prosecution is putting on the rebuttal witness, as you've commented earlier, what's needed of the defense attorney here, other than what Brian is saying, to kind of muddle the waters to really drive their case home?
Well, I think that this defense attorney is walking a little bit of a tightrope here. I think that the very fact that they put on a rebuttal, that this defense attorney should really shorten this cross-examination, give it as least amount of credibility as they can with making their point, because now I feel momentum starting to shift back to the state here, because if you notice now, the defense attorney on her cross is getting pushback. You don't want that when you're cross-examining. You want the answers and you want to move on. She's now correcting the attorney on certain things. She's really starting to look like the expert, and I think they should really find out what points they wanted to make them and get out, because I think they're losing some momentum here.
Yeah, and Brian, to you, I know that many, I'm not going to throw in, maybe you have the same theory or you don't, many believe that when you direct, the witness is the star. And when you cross-examine, you're the star. And to Mike's point, I think that the star of the show is shifting from the defense attorney to the witness, and when that happens, you're kind of in a losing battle.
Yeah. So remember what I was talking about, not trying to out-expert the expert? The way you avoid doing that is short questions, just like Mike said, short answers, and just making your points. And so it is rapid fire, because otherwise the expert gets to talk ad nauseum about all these things that are complicated and she gets to explain. You don't want that. Short answers, short questions.
Yeah. Well, we're going to continue with this case and more, giving long answers and probably long questions after this break.